just a pure evaluation. I make it very clear. Mr. Jones, I know you have a doctor. You're not my patient. I'm not your doctor, but I'm seeing you to write a report to your lawyers and so on. And if that guy says, oh yeah, my lawyer, don't even mention him, and next time I see him, I'm killing him. And if I really believe it to be true, and I think that guy is really a threat to the lawyer, am I bound by Tarasov to warn people? The guy's not my patient, and I'm not his doctor, really. You might say, well, you're a doctor, and he's a patient. Yeah, but he's not my patient. I think if it does come up, it's probably better to do it because you know that's the next logical step, right? To take the Tarasov, the warning thing. If you think it's going to happen, you might want to put in your report. If it's quasi, might happen, but it's not imminent, you might say, well, he threatened. Or I've gotten calls sometimes from attorneys saying, is so-and-so, he threatened to kill me. Do you think it's going to happen, Doc? I said, well, he is pretty angry at you. I remember one guy did that. And probably better if somebody else at your firm handles this case. Because he's saying now that you're against him, and that's, he's really very, very hot. He's very angry with you and has been aggressive in the past. We've got a history of it. So, well, you think he will? Well, as long as, he meets with another attorney at your firm and probably you won't be around when he shows up, I think you're okay. And luckily I was right, but...
So you didn't try to, hospitalize him at that point? Like, if he was making imminent threats to, kill...
Oh, you mean the injured worker or the applicant? Well, no. I could have. I would have had to do it by calling a pet team, right? Because he wasn't my patient. That's a good point.
Was it from just being kind of a jerk?
Well, that's a good point. Jerk, and one of these books here does say a guy who's threatening a lot of people and is angry a lot of people. That's a sign of malingering. I won't say that. But if he wants to show you how upset he is. But no, I've seen threats where put it this way: what if you're a claims examiner on a case? Wasn't planning on talking about this, but let's say you're a claims examiner on a case, and then he says, if that Marriott Travelers Insurance doesn't give me what I deserve, I followed her home from work a couple weeks ago. I'm gonna blah blah blah. I'm gonna shoot her and do this. If you're Marriott Travelers, you might want to settle the case and get rid of it, and give the guy what he wants, so to speak. And that's sometimes what they want. Another time, the way to go is 422 of the Penal Code, terrorist threats. That's what I would do if I was Marriott Travelers. I wouldn't just give in and give the guy what he wanted. But I would probably, you got to be careful. We haven't heard of, by the way, and I haven't planned on saying this either, but as of 1/1/2013, if there's a lot of failed backs, failed knees, guy gets certain problems because of anesthesia and is not a period of lack of oxygen to the brain, a couple strokes. Now he's upset. Now he gets depressed. Guess what? As of 1/1/13, that's going to be, at least the way it's written, not compensable. So, not the brain damage, but if he gets depressed over whatever happens, and we're going to be interesting to see what's going to happen if the law holds up. There are a lot of ifs, ands, or buts, and that's why I'm not... by the way, have you heard about the new workers' comp or the changes that'll be coming up in January? Yeah, so it's better not to be way off track. Even Bruce mentioned, he was an attorney, that some of it might be unconstitutional. He's heard that. I've heard that too. So it's a lot of speculation. We can speculate from forever, but let's see what happens. Yeah, but where's Linda today?
Sure,
I don't think she does much of this work. Like I said before, Seymour, I think I did one case with him in a year and a half, Seymour Pollock. And so we got the presumptions. Yeah, there's no presumption in psych claims. You can say maybe that I talked before about substitute teaching. I did it at my old high school back east, but that's a pretty stressful job, right? You're a substitute teacher in a high school, oh my God. Especially maybe 7th and 8th graders, middle school. It's almost... Right, Roberto knows he was a troublemaker.
Oh, that's right. That's the job.
But the kids take advantage of the substitutes. So injury issues. All right. Now this is it's interesting too, as you both, all three of you know, the legal system doesn't know what the hell to do with psychiatry, do we? We know what to do with a broken leg, we know what to do with a bad back. What do we do with pain and suffering? Well, first of all, there's no pain and suffering in work comp. So what happens then? All the pain and suffering gets transferred to depression, right, or anxiety, or explosiveness, or anger, or alcohol and drug abuse. That's where it goes. So then with Pete Wilson, they probably don't know who he is. Who's Pete Wilson?
The old governor.
Yeah, you remember. Good. 93. He pushed through in the legislature, right? He was a governor before Gray Davis and then Schwarzenegger and now Brown again. The only subspecialty of medicine that has guidelines have a high level, remember I talked before about preponderance, is psychiatry. And we're the only ones even told which book to use. Orthopedists aren't told what to use. And the interesting thing, as I said before, if you get hurt as an orthopedic patient, you get out, you drive into the parking lot, you haven't even clocked in yet, you slip into a hole in the parking lot, you're going to get paid in workers' comp. Psychiatry, you have to be there 6 months. But anyway, let me look at this. This is a big section. This is pushed through again in 92, 93. The economy in this state was not as good as it could be, not as bad as now, but whoever was on the side of the employer or the insurance companies, they pushed this through. Is it well written? Well, this is the issue here. Psychiatric injury should be, let me read it, should be compensable if it is a mental disorder which causes disability. That's how an injury is defined. Causes disability or need for treatment. And then you have to use DSM-IV text revision. So now here's the standard in section 32.8.3 B1. It says he'll demonstrate, and a lot of attorneys, by the way, make a mistake on this, and that's an advantage too of being a lawyer when you're sitting in there with them. I think it makes it a little easier to convince them sometimes of what you're talking about. That actual events of employment, and I'll tell you where the word actual comes from too, were predominant as to all causes combined of the psychiatric injury. Actual, so that means again it must be preponderance of the evidence, must be the word here is predominance. Well, what if somebody's hired with a 60% already found psychiatric disability on a prior job? Is it possible to have predominance to the new job? The answer is yes, because we're not talking about 60%, it means you have to only have 40% more. We're talking about the new injury. So let's say a schizophrenic is hired, or bipolar, who has a found, already adjudicated 60% disability. But what if he recovers from whatever stresses he had, and now he has 70? So, and this is what I argue with attorneys a lot, the extra 10% would be compensable. This first 60% is not. Now, actual events of employment, the legislature often takes, you might say, well, what does actual mean? It means real. For example, there was this case named Albertsons. A lady sued Albertsons, the food market. She thought, because the way her boss looked at her, that he didn't like her. And he was mistreating her. So she filed a workers' comp claim. And believe it or not, the Supreme Court of this state said he wasn't really looking at her any differently than any other employee. He didn't dislike her, but it was a false misperception that she had. But it was honestly held. So that was kind of a crazy law, because that meant if you misinterpreted something as a worker, your boss treats you fine, really, but you're paranoid, let's say, and you're not interpreting it correctly, you still have an injury, and it's compensable. So actual basically got rid of that. Actual must mean it really had to have happened, and the boss really had to have done that. So that's what actual is in there for, is to get rid of the phrase honestly held misperception. Because that seems pretty crazy, where if a worker misperceives what's going on with the boss, but that's the way they feel, it's compensable, and they get paid for treatment from being paranoid, and they get paid for their time off work, and it's not, nobody's done anything. I know it's no fault, but it all comes from our own mental problems. Now, I think you probably know the difference between impairment and disability.
Explain
Yeah.
to me what she meant by the 60% versus 70% with schizophrenia.
Yeah, sure will.
Extra 10%.
Well, that's a good question. Okay.
Okay.
Okay. Let's say that so there's no argument. John Doe had a 60% disability. Well, how do you know that? Well, it's because on a prior workers' comp case, a judge said it, so-called.
With a different job?
Yeah, could be a different job. Very good question. Different job. But some judge in this state said that John Doe or John Smith had a 60% psychiatric disability due to major depression or bipolar disorder due to the job. So now, after a period of getting treatment, getting well, and perhaps even going into the hospital, probably likely he would, then he's rehired at another job. And after, let's say, I remember I told you a 6-month minimum, usually 6-month minimum, unless it's, again, there's everything in workers' comp, there's exceptions to. Let's say after a year, he starts to feel stress on the job, because with a 60% psych disability, you're going to not be able to handle too much stress, probably. And then he starts to fall apart a little bit unless he goes back to the hospital. And now he comes out of the hospital with somewhat more impaired, somewhat more disabled. Now he's got more of a disability, he's arguing. And the defense would argue, well, he's already had 60%, how could he have preponderance of the new injury? Could be, how could that be with 60? But the issue is, we're not worried about the first 60. Forget about that. We're worried about the new injury. And the new injury is what gets him from the 60 that he was hired with to whatever he has now. And if work was mostly responsible for that, the stress of the job, let's say, then it's a new injury. Now he's 70% disabled. I mean, again, I'm putting numbers out there, utilizing what, like I say, like what they use now, the GAF. Now he's got a 70% disability. Now he's working at May Company. He's got 70%. When he was at Sears, he had 60. May Company is only responsible for the portion from 61 to 70. The first 60 is Sears. So May Company's the second 10%. I mean, the additional 10%. That's what I mean by injury is what happened at the second company. Even though you have 60 at the first, the reason I say 60 is because I want to get it above 50 so you can understand the concept of an injury. So, but the job is responsible, let's say, from getting them from 60 up to 70. So 10%. Do you understand that? So you start out with a 60, now you got a 70.
So you're just arguing about the factors that make up that 10%.
Yeah, those factors are predominantly due to the new job, that's right. Yeah, you get into numbers, but you have to. It's like in the criminal area, we have to know McNaughton and some of the other laws, of course, ALI, I guess you learn of that. But, workers' comp is all about numbers. Why is it about numbers? Because numbers, what do numbers equal? Numbers equal money. How much permanent disability? What are the checks going to be? How long are they going to go for? Is he going to get a life pension? Now, life pensions, I'm not going to get into that, but if you have a 70% life pension, you get checks for the rest of your life. But impairment basically is just, your heart is impaired, your legs are impaired, reduced ability, well, that's the lowered function of any organ, including the mental state. That's what impairment is. And then there's a translation from impairment to disability, which the AMA guides up on your shelf says they're not supposed to do, which the Diagnostic and Statistical Manual says we're not supposed to do. But you have to do it, because otherwise, how do you figure it out what disability is? And disability is really defined as reduced ability to compete in the open labor market. How much are you reduced? Well, that you're reduced by whatever the tables say. And that's when we use a complicated thing called a rater, R-A-T-E-R. But first, before you can settle a workers' comp case, you must become what we used to call permanent stationary. And the AMA guides, just because they can, I guess, they want to change the terminology to maximum medical improvement. Basically means you're as good as you're going to get and you're not going to change. You've reached a plateau, so the case is ready to be settled. Does everybody plateaus? No, you can go up and down, but there's a plateau, so now the case is, I think it's for a reasonable time is what the cases say. And like I say up here, not much change anticipated. So now your case is ready to be settled at some level of disability. So that's what the word permanent stationary, those magic words mean. Now, how is permanent disability rated? Again, this gets, like I say, it's highly technical legally, but the judge reads the reports of the doctors that he finds credible. And one thing that's nice in workers' comp, and I'm an AME, which means each side agreed upon me, probably 99.5% of the time, there's a case that holds that the judge, and interestingly, it's named the Power case, which I'll give next time, the judge is supposed to follow the opinions of the AME unless there's extraordinary reasons why he can't, because of the AME's experience and impartiality. So he'll pick the report that he likes, so he'll balance them. And by the way, trials in workers' comp, you might wonder, well, you said there's no juries. What's a trial? Trial is basically just a worker testifying. This is how I hurt myself, and then he's cross-examined. Maybe he'll bring in a witness or two. Doctors are not even allowed at the workers' comp board. It would be chaos if they allowed doctors there. As it is, there's hundreds of attorneys walking around. They don't want doctors down there. So our testimonies by report, which, as I said before, is under penalty of perjury, and by sworn testimony, by way of depot. So, have any of you testified much? How many times? Roughly.
A dozen?
Dozen?
Mostly just on like Ritz and
Yeah.
conservative.
Oh, and Ritz in the Department
Yeah,
95
not-
up there?
Not anything like that.
You testify much?
Yeah, same thing, just with civil commitment.
Okay, well, civil commitment. But can you imagine that, and I probably in all the, no criminal cases then, right? Not yet. Criminal cases, maybe a couple hundred. And some of that was back in the days with Dr. Scharmer, back in the mentally disordered sex offender when 2 or 3 guys had to testify. Few civil, commitment, you had Department 95 too. Department 95 used to be right here in Unit 3, when Unit 3 was around. But workers' comp, as you're an AME, remember I said before, your opinion must be followed? So do they take depositions? Yet the answer is yes. And I probably have 2 or 3 a week. So if you figure, that doesn't mean you wrote a bad report, but if you have so much power, the defense is going to attack it if you're helping the worker. The applicant attorney is going to try to attack you if you're not giving them enough disability. And if you have 3 depositions a week, that's 150 in a year. And for 30 years, what's that, 40? That's 5,000 times. That's a lot of testifying. And that's another reason I went to law school, so I could deal with these attorneys and raise my own objections. I don't know if a witness can raise an objection, can they? That's a good question, right? But now I can, because I'm my own lawyer too. Argumentative, you're harassing me, man, you're assuming facts not in evidence. I raise my own legal objections. At least now they listen anyway. So, but you testify a lot. And that's why they come after you as the AME. But it's good that you have, as I said, that power case, which it's an interesting name because it does give us the power. I'll get into what the guides are in a minute and ask your opinion about them. The other factors of disability, I think this may be changed somewhat, but it's still good to think about because it's been around for, like I say, 100 years. And this is something, objective factors, subjective factors, and then work restrictions. Let's say, objectively he has certain muscle atrophy. Subjectively, he's got slight to moderate pain, whatever slight to moderate means in the doctor's mind. And then his work restrictions, let's say he can't lift greater than 50 pounds. So that would be orthopedically. Psychiatrically, they've asked me frequently, they write the same letters to all the doctors. Are there any objective factors in psychiatry?
Sometimes like weight loss for depression or...
Yeah, it's not a bad one. You have to get them on a scale and check them out, yeah. But I basically say there's not really much in the way of objective, Subjectively, there's an awful lot. But psychologists have used objective tests, and I just say, well, just because it has a pencil and numbers doesn't mean it's objective. And some attorneys like that, and that's what I call it. It's really isn't every psychological test subjectively taken? right? As opposed to a blood test or an EKG. Work restrictions is tough too. How do you know what someone, well, presumably if someone's robbed a few times at a bank and they just say they have nightmares and they can't handle it anymore, it may make sense, but do you really know whether they can still do it? No, you don't. Anyway, those are, that's the way, let's say orthopedics rate. Now here, I'd like to ask your opinion on this because you both say, not both, all three of you say you use the GAF. According to the state of California, since 1105, since January 1st, 2005, if the patient, the applicant, the injured worker, has a GAF of 70, that's equals, WPI, by the way, as you can see, stands for whole person impairment. They claim that, do you agree with the fact that everybody with the GAF of 70 has no impairment? And that would actually equate to no disability, actually, too. Is that true? I don't think so if you read it. They claim, now where do these numbers come from? Someone with a GAF of 65, whole person impairment of 8%. And then it's adjusted the way it's done, again, and doctors don't do it. But you take an 8% on a school teacher is more than an 8% on a gardener or a truck driver. And they figure it out by age, occupation. But I don't know where these numbers came from other than what I said before, administrative fiat. Some administrator somewhere sitting at a desk came up with these numbers. I don't know where they came from. GAF of 60 is 15. And then GAF of 50 is 30. Is having a GAF of 50 twice as bad as a GAF of 60?
I mean, the problem with this is all of it's so subjective.
There you go.
Your
That's
gap is
that's right.
really subjective.
Well, the gap is subjective too. When I'm asked a lot about that, I say, well, that's really for clinics. You know, there's going to be perhaps a different doctor going in, maybe a Kaiser where there's a different doctor almost all the time, and some doctors incorrectly state that it's for doctors who are doing hospital work, and like I said before, to justify. You know, well, he had a 40 when he came in, he has a 60 when he leaves, so he's better. But I call this administrative fiat. And they get on doctors for not being substantial evidence, not having substantial evidence, not being evidence-based medicine, and the most important thing, the rating of the disability, came from somebody's head. A GAF of 40 would be that's a pretty high disability. And oh, by the way, the other thing where I think the legislature, at least for this, again, this is injuries up through New Year's Eve at midnight, the psychiatric, and this is where I think it makes the most sense. You multiply it by 1.4, so you get, let's say a 30 with a whole person, a GAF of 50 is a whole person impairment of 30, then you multiply by 1.4. 1.4 times 30 is what? 42. So that gets higher. Now, who says that psychiatric should be higher than neurologic? Again, some administrator. I didn't say it. But I give a lot of caveats when I write my report, criticizing a lot of this stuff. And that way I'm sort of ready when they try to cross-examine me saying, you know, and they being the attorneys will argue about, well, you said there was a GAF of 62, and my doctor says it's 58. How do you account for 60? It's kind of hard to argue one from the other, isn't it? 68, 50, 58, 62. But these, you know, and part of it is they get paid for showing up and taking my depot. But I use this very critically as to what's going on. And there's another law that I'll be talking about last time where we can bring in, and that's a good thing to ask you. You could teach me something maybe. Are there some things on the GAF that don't encompass all of psychiatric problems? Of course there are, right? Right? So there's another case, the Almaraz Guzman case, that says if what you're using, GAF or the AMA guides, is not accurate, you can add to it, or as long as you stay within the four corners. I talk about stress. That's talked about on page 362 of the guides. Now, voc rehab because I think stress tolerance is pretty important. Bulk rehab, now, like I said before, it's gone. It wasn't seen as all that successful because a lot of the people who would not benefit, and they seemed in LA County that they would either learn how to decorate cakes, make eyeglasses, be a locksmith, or cut flowers. They were all in rehab for like 4 jobs. And none of them ever got a job in any one of those areas, and they went back to their old job if they could work. Now that's stopped, and they just get what they call job displacement cash, anywhere from $4,000 to $10,000 for rehabilitation. Does it? And I also put in my reports. Has anybody here heard of the American Academy of Occupational Environmental Medicine? Probably not. Have you? What do they say in the ACOM or ACOM guidelines? What is the chance of somebody, if you know the answer, I say this a lot, what is the chance of somebody who's been out of work for 2 years due to a work injury getting back to work?
Less than 50%.
ACOM got, say 0, say nil. You were just speculating about the less than 50. They say nil, 0. So I say that. That doesn't mean they're not going back, and that doesn't mean they're 100% disabled, because there are other factors play in. Psych, motivation, other things are going on. What about a recipient of Social Security disability going back to work? Does that happen much? For whatever reason, but mainly psych. Social Security disability recipients.
Rarely.
Rarely, yeah, that's right. What percentage, roughly? I've done some research on the internet. I mean, nothing, the internet's not the Bible, but...
5? Less than that?
Less than 5? Yeah, probably less than 5. The thing I talk about is 1 in 500, maybe. I mean, it seems like but they can only make, somebody on Social Security can only work, 9 months and 5 years and make a certain amount, others they lose it, right?
No, Social Security disability is different than all this disability we're talking about.
Yeah, it's another form of disability, correct. It is not, and by the way, that's a good question you asked. Workers' comp was also set up to get patients off of welfare, to get them off Social Security, and to get them onto the back of travelers, off the back of the taxpayers, and it really failed because many, many workers are on Social Security disability. Probably half the people I see are on Social Security disability. Is that the reason Social Security is broke? Well, I don't know, the finances. But way too many people are on Social Security disability. It's a whole different...
So there's no, I mean, people can be both on workers' comp
Yeah.
and get...
The one thing you can't do is be on workers' comp, temporary disability, and be working. If you're doing that, that's fraudulent. You've got to do one or the other. But you can, and Social Security disability, I think, has to do with you have to be disabled for 2 years. 1 year could be in the past, 1 could be year going ahead. But workers' comp and Social Security go parallel. One's federal, one's state. And I get argued a lot with attorneys. Well, my client's on Social Security disability. Why didn't you say he was 100% disabled? Well, that's from every cause. He's also got knee disease and hip disease and a bad back and hypertension and bad stomach and obesity. I'm just talking about psych.
So
But
the Social Security disability and workers' comp could be, they could be getting it at the same time.
Right.
And in order to get Social Security disability, do they have to have held a job
No.
at some point? No.
No.
Anybody can file for...
I think you just need a Social Security number. If you don't have a Social Security number, you might be in trouble. But if you have a Social Security number. Now, there was a guy that I saw, I have to tell you this story. He, I don't know what his immigration status was, it really doesn't matter that much. He had a child, and that's why it's important to take a family history. This gentleman, how is your 5-year-old? Well, he's got problems. What kind of problems? And then you find out that he's brain damaged, maybe cerebral palsy, we don't know what happened. He's in a wheelchair, in diapers, can't speak, possibly blind, deaf, whatever. So now this guy, the baby's 5, and I take a history, and of course I'm sympathetic and so on and so forth, who's taking care of him? Oh, my wife. So, are you able to work? No, I can't work. Blah, 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 I got a bad back. I remember hearing this through an interpreter in my office. By the way, interpreters are provided by the insurance company by law. They must be provided free of charge to the worker. So This 5-year-old, I always thought Social Security disability was to replace lost wages. How is this 5-year-old collecting $500 a month? What would he be doing? He'd be in kindergarten or nursery school. Where's the $500 a month? What's it replacing? The answer is nothing. And then guess what? This gentleman who I saw, his wife was getting $500 a month for taking care of the baby. So she's getting $500, and the sick baby's getting $500. This worker's getting nothing, but the family's getting $1,000 a month. That's apart from workers' comp. But I don't understand. I would have thought that Social Security, you needed to pay into it, do something, be 18. Now you're being prevented if you're sick from, let's say, working at McDonald's. You can't do that now. But I don't understand how a 5-year-old gets disability. I guess I have to ask my congressman. I don't know. But that's part of the reason that the system is.
You don't have to contribute to it, because that's always what I thought.
No, you don't. And the only reason I raised the immigration issue, I don't think the father and the child was born here, I'm sure, but I don't think the father or mother had ever paid in and didn't even have Social Security numbers. Now, I understand that newborns get Social Security numbers before they leave the hospital, but he didn't pay in. There's also something that's way too complicated called Medicare set-asides, where the Medicare won't pay for your work injury anymore. Years ago, the attorney would say, settle your case for $100,000. Oh, what about my bad back? I need care for the rest of my life. Oh, no, we'll let Medicare pay for that. You're on Social Security. Because what goes along with Social Security disability, you get Medicare after a year or two. Oh, Medicare will take care of your bad back. Now Medicare has discovered computers, and they've discovered that, oh, there's such a thing as future medical care, and there's such a thing as car accidents. Wow, so now they will, if you have patients who are on workers' comp and Social Security, they're old enough in their 60s, let's say, or even younger Social Security disability, they will get a letter from Social Security saying, oh, we found out you're in a car accident or you're collecting workers' comp, and don't get any treatment on it because Medicare is not going to pay, or they're going to pay a limit, but a high limit. The initial has to be paid by your employer. But so that's called Medicare set-aside, and that's only since Medicare figured out how to work computers. Before that, you could get the Medicare to pay for the treatment. So this is the job displacement. I hear, again, many people, what are you going to do with your $10,000, Mr. Smith? Well, I'm going to start my own business. Then you end up seeing them 3 more years later, and they're more depressed. And what happened to that $10,000? Oh, I went to Vegas and gambled it away. Oh, I got my new wife, went to Hawaii. What about your business? Oh, I never got around to it. So that doesn't work too well. Physician issues. Let's see what we got on that. All right, well, we have a bunch of, again, like I said before, every doctor, osteopaths, optometrists, even the only one who cannot write a permanent disability report is a social worker. You can be a foot doctor, an eye doctor, you can be a chiropractor, write a report for somebody's back. I know Roberto has a brother who's a chiropractor, but he can't write a permanent disability report. No, excuse me, he can, which I don't agree with. I sometimes will write a report and say he's only a physician because the labor code says so. Don't we have a situation like that with county jail? County jail is a psychiatric hospital because the legislature says so, right? Don't they handle the incompetent, the 1368s? So many of them, they can't move them out, and there's too many problems. And it's the biggest county hospital. It's the biggest psych ward in LA County. So we'll solve that problem and just say, well, the jail is a psych hospital. To me, that's being a little bit intellectually not honest. So you got the treating doctor who has to submit a report every, this might be on your test if you take a QME exam, if you get into workers' comp, I think every 45 days. The consulting doctor, if the treating doctor wants a consult, let's say an internal, check his patient out for heart disease, stomach disease. The evaluating doctor, which I do a lot, that can be on either side. That's one of the things that happened under Schwarzenegger. He tried to bring more of the doctors out from the far work-related side to the insurance side, push them a little bit towards the middle to try to, the theory is cut down on battling experts. I think it's worked a little bit. And so there's this qualified medical evaluator. I've been that since 90, and they started giving exams in 94. Qualified medical evaluator just means you passed the test. And then there's what I said before was the agreed medical, AME, which is one of the few areas where workers' comp is better than I think the civil arena, where each side picks one guy to be the reporting doctor, and everybody's going to follow him usually. If he knows the law and does what he's supposed to do, they'll follow him. It cuts down on some of the litigation. Like for civil court, each side will get their own side. There'll never be an AME. Then there's the last one, which, like I said, was what used to be IME, Independent Medical Evaluator, appointed by a judge. Now it's called regular physician. Again, it's to get away from being called a forensic expert. But who is a regular physician? Me. Maybe I heard that Dr. Jax is coming in next week, probably him. People who know the law. Now, the physician conduct, we're told that basically has to do with all the paperwork that we have to submit, which is very, very, it's on the website. You'll see that it's amazing how much paper there is. And it goes through the usual stuff that I think, I won't say it's an insult, but doctors should know about it. You treat patients with respect, so on and so forth. No harassment, of course, the silliness like that. That's listed. HIV status is very interesting. To me, it shows the power of certain lobbies in the state. Believe it or not, if you see somebody in workers' comp who's suffering from, let's say, significant depression, you're not allowed to ask. And oh, by the way, they're blaming their problem on a back. It's possible to be a nurse who is HIV positive. Now, her claim, then she's got extra protections as well, where her name would be Mary Jones, AKA, and then her name would be, or Mary XXYY, and her case would be given an anonymous number to keep her privacy. So that's the only really issue that's private. And as a doctor, I will tell patients that, or applicants that, examinees that, I'm allowed to ask you any question I want. Can't make you answer anything, I'll say, but I'm allowed to ask you any question I want, except do you have HIV situation or have you had AIDS? And usually they'll answer, because when you're being honest with them and tell them what you can answer, they'll go ahead and answer it. Anything else you can ask. Have you been to prison? Have you used drugs? Divorces? You're allowed to ask. Of course, they can refuse to answer whatever they want. But it's interesting that HIV is the only protected area, probably because certain pressures were put on the legislature, is what I think. Or maybe certain legislators with certain points of view pushed that through. Anyway, so that's the one thing that, and it's a silly thing that's written in the physician's guidelines. It's usually not important. It's usually not important to I just see how much time we have left, about 15 minutes. It's not important to know. But hey, if I see a guy who maybe because of a lot of tattoos with dirty needles or sexual behavior or drug use, and he's looking, perhaps he's been out of a few problems, I think it's reasonable to ask that question, but in the book they say you don't have to ask. So there's ways to get around that, but it's difficult. Perhaps you could ask a question like, do you have any chronic illness? Anyway, so that has to do with physician conduct. Certainly you don't want any complaints made about you asking things you shouldn't be asking, but that's the only area where you really can't. Now, it's rather surprising, the minimum length. And this is not just a treatment follow-up visit. This is an initial comprehensive evaluation. Can you believe it? The orthopedist only has to spend 20 minutes. Let's say somebody has a bad shoulder, fell, has a twisted neck, low back hurts them, and they're making a few other complaints. The orthopedist only has to spend 20 minutes with the patient. I wouldn't seem, to me, last year I had hip replacement. That I probably spent 20 seconds with him, because after he looked at the x-ray, he said, yeah, hip shot, you need surgery, but replacement. But this is workers' comp. Again, if that case was workers' comp, he would have wondered what happened to my hip. I wore it out playing sports. But he would have had to take a history, like I read before, everything that I've been through and how blah, 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 how I why now I need what's the causation of the needing the treatment. But 20 minutes is a very brief exam, but orthopedists are allowed to have historians. What's a historian? Does anybody know? How would,
Someone who takes history for them, they do it separate.
Do
just
we
the
use-
exam?
do you use it here? Yeah.
I would. No, we
We don't, right? But they couldn't do the job you do, right?
don't. No.
No. So orthopedists use a historian, but they'll twist it and say, well, I had a historian, and then I took the history based on that history. So in effect, there were two histories, making it better, where he's obviously the guy who should be taking the history. The internal, which is amazing because somebody could be, 60 years old, 1 or 2 heart attacks, smoke, have a problem with diabetes, again, the family history, could be a cop with a presumption like we talked about. Long history is needed, examination is needed, maybe an EKG, other things are needed, blood tests and so on and so forth, which takes time. Well, he doesn't draw the blood probably. But that's only 30 minutes. Now, a lot of the doctors these days use long, multi-page questionnaires. I don't really like those. But I like somebody to come in where they don't know what I'm going to ask them. I think it's giving too many clues what you're going to be bringing up. Now, at least psychiatric, a little bit longer. Can you do a thorough, more than a competency to stay in trial, which might be quicker if these guys are very out of it in the first few minutes, you know that. What do you think should be the minimum length of a face-to-face, comprehensive workers' comp evaluation when you've got to figure out why this person who's maybe not 21, triple that. I know here Dr. Pollack would want us to do hours and hours and have them come back. What do you think?
Seems like 2 hours.
2 hours
That's what I was saying.
minimum? Yeah, 1 hour seems to me on the short end to me. And they also said while you're having your patient, and this is, you get down to nitpicky stuff, but it is interesting. While you're having your patient be psychologically tested, if you're doing, let's say, an MMPI, sticking your head into the examination room every 5 minutes while they're sitting in there spending half an hour doing the test, that doesn't count. So that's obviously come up. And
Seems like there's a lot more stringency with the psychiatric stuff. I mean, it's
Well-
almost like kind of like a discrimination.
I couldn't agree more, and I think that's one of the things that's going to come out in the new law. I think it's going to be ADA fought. I think they're discriminating against psych. I mean, if they really wanted to save money, why didn't the legislature say we're not accepting back injuries, which are the most costly injury? We're not accepting orthopedic injuries. We're not accepting heart injuries heart disease in an effort to save money. But now they're limiting psych.
It's almost analogous to what was going on in the criminal court before the mental health court came about. Just sort of this discrimination against patients who had mental illness.
Yeah. Anything new going on in the mental health courts as far as we had the cell case that changed competency, right? So what do you involve? Basically, it's just commitment, right? Commitment law, right? So what do they do? You show up at the probable cause hearing, or you show up at the 14-day, or whether they need a conservator? Which one? Or both?
Oh, yeah, we do everything. We write the conservatorships.
Yeah, I remember you know about the Roulette case, right? R-O-U-L-E-T. Did that say it has to be a unanimous jury verdict beyond a reasonable doubt? That's like a tremendously high standard for conservatorship. Isn't that the standard, beyond a reasonable doubt?
That's what they say, but I don't think in practice, I don't think the judges really hold that standard.
Yeah, I was around when that was the law. Rose Bird was the head of the Supreme Court, I think, in the mid to late. That helped get her pushed off the court, mostly because of the death penalty, being against it. But she said, well, her standard was, well, it requires a unanimous 12 out of 12 jurors beyond a reasonable doubt to lock somebody up. And loss of freedom is loss of freedom. Really? It makes it almost impossible to get a conservatorship, I would think. But you think it's the judges?
Yeah, like in 95, even though they might say that it is, I don't think in their mind they hold, they hold the
could be lower. Could be maybe
yeah.
clear and convincing, or even
Yeah.
just
I think you were
preponderance, 51, yeah.
The 20 minutes for ortho, does that include the historians? Or it's just the doctor?
Supposedly it's the doctor. It's minimum time of face-to-face contact between the doctor and the applicant or the injured worker. But this is the initial examination. Remember, he's never seen the patient before. He's going to be, especially if they come in with multiple, they have a neck, they were in a bad accident, if they're a little bit older, they're going to have all kind of arthritic complaints, and he doesn't know what's coming from what, so he's got to take a history, and the answer is it does not include the historian.
Well, what if it's tests and physical exams? We don't have that. So, it's not comparable.
Which tests? You mean from the...
Like they can do a physical exam. They can look at an X-ray. They can look at an MRI. We don't have any of that.
No, we don't.
We don't have anything like that. So we have, our exam is our mental status exam, which takes...
Mental status and the history, though, because you're doing the mental status during that, right? Do you do a lot of psych testing? Because the psychologists in workers' comp have pushed it, and they almost got it through where it's almost it's mandatory. And I say, no, that's subjective, and that's one of my arguments, that some people like it, just because it has a pen and paper and is scored with numbers. An MMPI can be exaggerated, can be under reported, it can be over reported. It's not just the LFK scores, it can be, I always argue that it was made for treatment, it wasn't made for litigants. I bring up, every time there's a big murder case, they're not usually arguing about the MMPI, the shooting in Tucson, Arizona, the stuff going on in Colorado. That's the last thing that's done. Yet you got psychologists out there saying it's so important. The stuff that's purely subjective, the Beck depression inventory, the Beck anxiety, it's all, check a box and how do you feel? You're letting the person almost rate themselves. But there is not much in the way of objective in psychiatry. One of the things I've done, and I was probably the only doctor in addition to one other who's been doing it, who did it. I came up with the idea independent of him. And then a few doctors are doing it now because the ACOEM guidelines say it's to be done, is checking urine for narcotics. They say if you're regularly prescribing Norco or Vicodin, you should check. They're really looking at to see if the person's taking too many. But what about the person who doesn't have any? You prescribe them 3 Vicodin a day, a couple Norco a day, and you do it. They don't say to do a surprise test, but I think if a test isn't a surprise test, it's worthless for that purpose. There's no blood. There's no drugs in the body, no drugs in the blood, no drugs in the urine. Does that mean the person's lying to the doctor? Does it mean they're not in the pain that they say they're in? Yeah, probably both, actually.
Selling it.
Now, one of the best things I ever did, and I have to tell you this, is it bragging a little bit. Took a drug history. I don't draw the blood myself. I'll get a lab tech to be over. And of course, you never can force it on them if they don't want to do it. It's a battery if you force it. Anyway, so I used to have a lab right next to my office in Santa Monica. It was very convenient, but it's closed, and I was set to send them over to St. John's. She claimed she was taking about 3 milligrams of Xanax a day, so and Wellbutrin or something else, whatever it was. So I said, the Xanax doesn't seem to be helping you, ma'am. It's boy, you're still real nervous, right? She said, yeah, I am. I said, you have some Xanax today? She said, yeah, I took 1 or 2 before I came, and how long have you been taking 3 milligrams a day? She said, oh, for weeks and weeks and weeks. I said, all right, well, you get them stuck. You say, well, why don't I send you over to St. John's Hospital? I don't think she's I'm thinking she's exaggerating from the whole thing. And I said, well, send you over to St. John's. We'll draw your blood, and we'll see. Why do I need to be tested? I got a doctor. Well, I just want to check something. I'm the AME, and my opinion will mean more than your doctor, or mean a lot. And let's see what we have there. It might be working against some other drug. You tell them something. And then I still remember this, filling out the prescription to send her over there. Blood test, alprazolam, Xanax. And then I'm thinking to myself, I don't know where it came from, but it was brilliant. I wrote down urine test for Xanax as well. So about half an hour later, because I knew that I could tell from when she left my office and when she was at St. John's to be tested, she had some detectable Xanax in the blood, but none in the urine. What does that mean?
Was it recent?
She took it on her way to the hospital. She took a whole bunch on her way to the hospital, but it wasn't enough to go through the kidneys into the urine yet, but it was in the blood. And she lost her case because of that. I don't know why I put down urine. And sometimes you get a letter from the attorneys saying no invasive test can be done. So you can't do a blood test or a urine test considered invasive. But usually I don't know until they're, but that was a very interesting case how that came out, that she hadn't, it was in the blood but not in the urine. But not much testing is done, except I said recently a little bit for narcotics. These are the books, these are the recommended readings. Like I said, the California Labor Code, I mean, you got an insomnia problem, you thumb through it at night, that'll knock you out. But there's just good sections in there about horse plague and skylarking and learn these new words. And, 10% of my battery's left. Okay. But again, a big section in there, workers' comp. The second section is on administrative regulations about that. That'll be about how much we can bill and the amount of time we have to spend. The AMA guides, of course, that's we have it on the shelf there. The 5th edition is used. The reason the 6th is not used, does anybody use the 6th? Has anybody read it? I think it's even more conservative than the 5th. I mean, as conservative as Arizona is, I think their legislature said we're not going to use the 6th. They're supposed to, but we'll go back to the 5th. These other two books are what I've mentioned up here. The other book I couldn't find. I had it on my list, but it's out of print. So, factors of PD. Let's see. What page are we up to, Roberto? Oh yeah, we're almost done, right?
Yeah, I think you're right there.
GAF now, that's what I talked before, loss of earning capacity. I argue about it all the time. You're on my case for not being scientific, not being evidence-based, but the whole thing is based on some administrators' ideas. So that's what PD is, permanent disability. That's the key word. PD stands for permanent disability. Workers' comp is full of acronyms and abbreviations. PD, TD, AMEs, IMEs, QIWs. I mean, that's everywhere. This is what I'm going to do next time. By the way, is anybody interested in workers' comp later on down the road? Because there's a lot of people. Like I said, there was over 1 million cases compared to. And I remember Dr. Pollack, he used to talk all the time, if you're going into psych and law or forensic medicine, you're not going to have a good living because it doesn't pay. Well, of course, a lot of criminals don't have money, and there's not a lot of personal injury around. Family law might pay pretty well, but it's got to be competitive, right? Got to be I'm not a child psychiatrist. And are you a child psychiatrist too? You are? Because you could probably get on the panel then, and then the families have to pay you. But workers' comp, it doesn't pay fantastic, but there's a lot of need for it, and there's a lot of the evaluations too. Actually, that's why I'm here, the evaluations. And there's, like I say, over 1 million cases a year. That's a lot of cases to go around. 1 million, boy. There's a lot of.
Bill per hour for workers' comp?
Yeah, there is a set amount. I'll tell you what the amount is. The set amount is much higher than for treatment, and that's why the treatment. The set amount went up, the amount per hour, and we're able to round up to the next hour too. So if it's an hour and a half or an hour and 46 minutes, it's $250 an hour. I mean, that's not mind-boggling money, but and there's ways sometimes you can get your usual and customary as well. But that's what it is. But then if you're agreed upon medical examiner, I didn't say it here, you get a 25% bonus on top of that. So the $250 becomes $312.50 an hour, which, 300. But in workers' comp, they used to pay it's 1973 rates for treatment, $98.40. Now they're following Medicare rates. And what does Medicare pay for an hour? Counseling, therapy? In 70s. So you're talking about $78 compared with $300 or $250 or $312. That's why more of the people who do workers' comp are in the litigated cases or the evaluation. So I'll be back here January 7th next year. 3 o'clock, and I'm going to discuss, because every one of these issues I discussed today, just like I know while I was here, I was going through a lot of diminished capacity, and that's not even around anymore, right? Diminished actuality, you call it now. But there's a lot of cases on it, right? And that's what I did when I was here, and every one of these issues in workers' comp as case law. So that's what I'll do next time. Any other questions before my computer stops working and run out of film? That'd be a good idea what Bruce said, by the way, to show up at a workers. Maybe anybody's welcome to come by my office, and you have the name and number there, and I give you the pens with my website to see how you do it. I mean, it's a little bit different. There's also guys on death row that I've seen, and some of them. Cal was going to mention one of the guys that we saw, the biggest mass murder in the history of Glendale. I just noticed that that fellow had committed suicide. But is it life and death? Well, to the person sitting there with you, it is, because it's a big situation for them, and especially if they can't work, their family, their wife is leaving them, kids are upset. So, is it as big as high publicity murder case? No. All right, so that's it. We're out of time. Thank you for your attention. Thank you. We're done, Dr. Gross. Thank you.
No problem.